I'm Paul Brownstein. I'm an attorney here in Southampton, Bucks County, Pennsylvania, and I'm here today to have a little bit of a conversation about some of the work that we do here in our office for our clients. An important part of what we do here, and a lot of it, is handling people with family disputes. Family law includes things such as divorce, custody, support, adoptions, all the sorts of things that people come to see me about. They're often not very happy. As I like to joke about a little bit, nobody comes to see me when they're in a very good mood. The whole situation seems emotionally and factually overwhelming. There's so much going on, they don't know where to turn. They get advice from friends, which is kind of what you get, friends' advice, worth what you paid for it, or what they see on TV, or what they imagine. And you can always imagine way worse than what is actually going to happen. So for that reason, I'm going to give you a little bit of an overview of how divorce cases should be handled from a perspective of doing it in the most useful way. Frankly, there are really only four things worth understanding about divorce. That's really all there is in them. And that's why divorce cases, for example, seem to be so overwhelming. You have so many balls in the air trying to juggle all of them that it all seems impossible. And the trick to thinking about it is to handle each of the four individually and separately one at a time. Because the big problem is made out of the four little problems. If you solve the four little ones individually, the big problem goes away. The complexity in most cases is an optical illusion. Mostly, divorce cases, even in bad situations, are very often ordinary things we've seen time and time again. And that's a good thing, because if things weren't historically predictable and understandable, then every single case would be a unique case, and there'd be no way of knowing what to do. If there's no way of knowing, who needs lawyers? The theory of hiring an experienced attorney is we've been there many, many times, and our job is to do two things. Protect you as your advocate from things happening to you that are bad, or maybe going after things that are good for you to make sure you get them. That's one job. The other job is to be your shield, your counselor, your advisor, so you know what's going on and have the comfort to know, knowing the facts, things aren't often nearly as terrible as they feel at 3 in the morning when you're thinking about it. All right, so what are the four things? One is mechanically how divorces happen in Pennsylvania. And that's because if you understand the structure of it and how it works, most of the other stuff makes more sense. The second thing is when there are children, we have custody. And the third thing, whether it's children or not, we have support. There's child support. There's also spousal support. I should point out, by the way, that spousal support is support paid by one spouse who is economically better off to the other spouse. Contrary to what I hear from unhappy husbands in cases, it is not the anti-husband statute. It is a production of the court that sees to it that the one who is less well off economically is put on a level playing field. And the fourth one, which is usually the most complicated one to do business with, is what's called equitable distribution. That means property, assets, liabilities being distributed and worked out among the parties. Equitable sounds like it means equal. It doesn't mean equal. It means fair. And the truth is, it's not fair. Because there is nothing fair except in the legal abstract about giving money or property from one party to the other, because that's what happens in divorces. You don't get fair in court. You get law. And a lot of times it's not very fair. And at this point, and at many other points that people talk to me, I will say to them, if you want fair, you should not go to court. You get law in court. Fair is what you get if you pray to God, or whatever particular being you have to believe in, and God will be kind to you, perhaps. But in law, the bad guys win all the time. The one who wins in court, who gets what they want in divorce cases, if it isn't a predictable outcome as it should be, is the one who's best prepared. If you're best prepared, which means have a good lawyer, have a good background, have the facts straight, present it well, you won't get hurt. Or at least, not to be funny about it, you won't get any more than the law is going to make you get hurt. All right, well, briefly, let me tell you about the structure of divorce, which is the first thing I mentioned. Most divorces in Pennsylvania are no-fault divorces. No fault means that the grounds for divorce is that not someone. Someone is not at fault. It means the marriage is irretrievably broken. You can't put Humpty Dumpty back together again. And you prove that by doing two things. And you have to prove it. You don't just say, oh, I have grounds for divorce. The court has to be satisfied that it's true. The first thing you have to do is you have to say the marriage is irretrievably broken. That is the crucial thing you do. The second thing you do is either prove it by signing a document called an affidavit of consent. You're consenting to the statement the marriage is irretrievably broken. If husband and wife both sign such a document, the court's position is, we're not going to argue. You're right, the marriage is broken, you both said so. But you can't make a person agree that the marriage is broken. And often people will not agree, even if they think it's so, because you don't agree to that, because the next step is go and get divorced. That doesn't get you divorced, it gets you the right to be divorced. And so people will not agree to let you go and get divorced unless they feel like they're getting what they think is a fair deal out of the case. If I don't think I'm being treated properly, I'm not going to agree. Well, what if you don't ever agree? Does that mean you're hung up forever? No, we have a out in this case. You have to be living separate apart long enough for the court to be satisfied that was an irretrievable breakdown. And what is that? Well, before in 2016, it was a 2-year living separate apart. They amended the law in that year, essentially to say it's 1 year. If it's before that date, your grandfather did is only 2 years still. After that date, it's 1 year. You do an affidavit saying so. The other side then gets a little time to object, saying that isn't so, which is sometimes the intriguing argument in the court as to what happens. I had a case once where one party said it was 1998. The other party says it was 2016. You have to say to yourself, is this even sort of possible? What was the reason for that? Well, very often the reason is not to do with when you really broke up. It has to do with what do you get as a consequence of proving when it happens. That's going to be very important in what I talk about in a few moments, property division, because there it makes a big difference, not just getting divorced. All right, the next thing I mentioned was custody. When custody is not an issue, and very often it's not, then there's not a whole lot to do except write it down, get an agreement, get on with it. And in the majority of cases, in fact, with some negotiation and some unhappiness perhaps, the husband and wife, the mother and father, will come to some reasonable understanding of what do we want to do here. A lot of times, it's what it looks like. Mom gets the primary, that means the kids live with her, because very often that's what's been going on, and that's acceptable, even if not happy. And dad gets to see the children at other times, either by schedule or by agreement, because they get along with each other. But when the parties have a strong difference of opinion about where these children should live, then custody becomes the tail that wags the divorce dog. They will fight mercilessly with each other sometimes, unfortunately, on the divorce playfield in order to get what they want out of the custody case. And it doesn't much matter how come they're fighting, it becomes a real trying, and I don't mean court necessarily, difficulty for all the parties. And we spend a lot of time involved occasionally in custody cases, and it is custody that usually slows a divorce down. Because if I'm not getting what I want in custody, a party might say, why are you asking me to agree to be divorced? Or sometimes it's, I'll show you, you think, we'll see what we have to do here. That's custody. When you get done with it, most often they will come, the parties, to some kind of an agreement. All custody agreements are by their nature temporary. You could always modify a custody agreement, either by agreeing to another time to something else, facts have changed, situation's different, or perhaps because you can't then either, and then you have to go to court. And like many things in family law, a judge will decide. Please understand, if you can stay out of court with a judge in custody, and for that matter, for many things, that's an advisable thing to do. A judge will do what a judge thinks is right. And what a judge thinks is right may not have a whole lot to do with what either parent thinks is right. And putting it before the judge, you get a decision, you're kind of stuck with it. So you ought to try, both because it's less aggravating, less time consuming, if you're paying lawyers way less expensive, to make an agreement for the best interest of the children. People must remember, ultimately, custody is not about the rights of the parents at all. It's about what's best for the children. And parents sometimes, much more often than is good for them, forget that in their rush to do what they think what each of them thinks is right. They want what's fair. There's that word again. Fair usually means what I think is right, because I wouldn't think it if it wasn't right. That's fair. And when two people think something's fair and they're saying different things, then people like me wind up going to court. That's how custody works. You can always modify it. Custody is all over in Pennsylvania when the child's emancipated. Emancipation by court decision, Supreme Court in Pennsylvania, is when the child turns 18 or graduates from high school, whichever is later. There are some wrinkles, like there are in many things, where that might not be exactly the court does, but generally speaking, that's pretty much how courts look at it. The next topic is support. Two kinds of support: child support and spousal support. Child support is basically for an average couple, and by average I mean under state law, generally people who have combined net monthly income of less than $30,000. Anybody more than that are not average people. These are wealthy people, and those people tend to live their lives and spend their money in different kinds of ways than average folks do. Even $20,000 combined net is more than the average kind of family would see, but they all still fit under the so-called Pennsylvania support guidelines, which were invented to give predictability and certainty in support cases, which again, when you do it by a mathematical, equally applied formula, often you get a result that somebody thinks is not very fair. There's always somebody thinking it's not fair. I deal with fair a lot. I used to have a dictionary on my desk where the word fair was whited out, saying, you think it's fair? Show it to me, but because you don't see fair a lot. But it is fair if fair means it came out like it was supposed to. If supposed to means consistent with law, rules, and history of cases. All right, so what is the Fair Pennsylvania Support Guidelines? Basically, and this is not necessarily what happens, but it's pretty much a good description of the process. You add together the net income. That means after taxes and Social Security and other obligatory deductions from each party's income. What do they get as a true net? As an example, sometimes somebody has a 401k and they're not seeing that money, yet they're able to get it. So the court says, well, you're getting it, you just didn't see it. And again, the person who is now being charged having an income bigger than they're actually getting in their hand says that's not very fair. Well, nobody makes you participate in a 401k unless your employer does. Pension rates and 401k rates are often obligatory, and you're in a union environment. You don't get a choice. If you're a governmental employee, you don't get a choice. Then you can deduct it. Otherwise, you're adding it back into your net to get a so-called true net. You take both nets, husband and wife, or mother and father if it's not a divorce case, and you have a combined amount. And then basically the state has figured out in the abstract what would an average couple, and of course there's no such thing, but what an average couple who have that amount of combined income, net, devote of that money to the needs of the children they have. So if we know what the combined net income is and how many children there are, we then get a basic number that the state calls basic support. I call it basic needs, not to get confused, because it's not the support you pay. And then the one who has the children more than half of the overnights, called primary physical custody. The one that has that will collect, if they want it, from the other parent, which could be the father, it could be the mother, different situations apply, will collect a percentage of that basic needs number. That is that person's percentage of the combined net income. A very fair allocation of responsibility. Both parties have to care for the child, have to deal with the child's needs. They know your income is, they know how much they think you need for it, you pay your percentage. That's how it works. Very fair. And it is always, when you have a court order, assuming the person's a W-2 employee, by wage attachment. It gets paid automatically straight to the state, directly to the bank account of the other party. Like custody, support is also always modifiable. The basic reason for getting a modification is something's changed. Incomes went down, maybe somebody lost a job, things happen. Or maybe a child's been emancipated. You have 2 or 3 children and one got out of high school. Now you have to redo the numbers because Surprisingly, if you have two children and one's emancipated, the numbers don't go down 50%, because it doesn't take half for one child's need of what it costs for two children. The state's very clear about all that. There are many, many, many written up rules in the guidebooks that talk about this at great length, and the state follows them. So that's how that works. In addition, there's spousal support. Spousal support is what a spouse gets in addition to child support, or if there's no child support, because they have a right to get it, and in order to collect it, basically, the one that's looking for it has to be earning less money than the other spouse. And the basic formula, even though it's not how it's done, if there's no children, you take the two nets, you subtract the lesser from the greater, take 40% of the difference. That's a lot. 40% of the net difference between the two incomes. And that's what's paid in spousal support in the absence of child support. If there is child support, you calculate child support and all the things that go with it, which I'm not dealing with here in this relatively short talk. And you get a net number. You know, how much is it? You now, again, take the lesser income, subtract it from the greater income. Subtract from that money necessary and needed for child support. What's left? That is 30% of that difference. And that's spousal support. Another kind of support called temporary alimony, I will not deal with here. It's calculated much like that, but the reasons for doing it and why aren't what this is about. So I've now talked about how you get divorced, what's custody, what's support, what's left, property division, equitable distribution. It can be very daunting to figure out what we're doing here, but in a capsule, I'm going to say what really matters. You add up what are all the marital assets. A marital asset is anything that has value that was obtained or to which a right was accrued to get during the marriage. Basically, date of marriage to date of separation. Property you owned already before the marriage is not marital, unless you made it marital. For example, you had a house, you got married, husband, wife in love, you put the spouse in the deed. People do that. Now the premarital, non-marital asset became a marital asset. And it doesn't matter if anybody contributed money from the other side. If you are working on accruing a right for a pension or a 401k, it's coming through your income. It's your earnings that paid for it. It's the sweat of your brow or the wrinkle in your white collar, whatever the happens may be. You think that's your money, and it is, but the deal is, under Pennsylvania law, that is a marital asset. It's accruing value. The amount that was accrued as of the date of separation, generally speaking, that's also a marital asset. That gives some parties a lot of unhappiness. I hear all the time, what's fair, again, about my spouse getting a share of my pension that I work for? And the answer is, it's fair because that's what the marriage law basically is about. It's as if you have two people who become business partners. And now one of them is a lazy worker, and the partnership breaks up. You don't think, do you, that the partner who's leaving the partnership doesn't feel and likely going to get half of the partnership? And if you think about it, marriage in a way is a partnership too, just like that. Okay, so that's so-called equitable distribution, and you put in the form as well marital debt. What's marital debt? Again, any debt incurred during the marriage is a marital debt. There's two kinds: unsecured debt, things like credit cards, bank loans, money you owe to your bookie maybe, stuff like that. Those debts are debts that are divided at the time you divide up the assets, just like you divide up the personal property, the real property, all that stuff. And then there are secured debts, things like a mortgage on a house, a loan on a car. They are secured by the property. Those debts travel with the property. So if wife gets the house, because she wants it, as often is the case, she's going to be responsible for assuming the entire mortgage, and husband is off the hook, or vice versa. That's how that works. Car loans, well, both cars I hear often are owned by one of the parties, and the other party is driving around in one of them. If you have, during the pendency of divorce, a marital asset, you're required to protect that asset and not let it lose value. It's called waste. So if you are driving a car that's secured by a loan, it doesn't matter if you're not the one who took out the loan, you're using the car. Doesn't even matter if your name's not on the car. You must not let that car be repossessed. And this becomes case in court a lot. And the outcome is not always as predictable as the people would like to have you believe. I can tell you that from my personal experience. You see this a great deal. In the end, the only thing left over after all that is alimony. To some people's surprise, there is alimony in Pennsylvania. It is not automatic. It's not guaranteed. The basic rule for calculation is very similar to spousal support. But whether you get it or not, now instead of just saying, I'm separated and make less money, now you have to show you have legitimate needs. And generally speaking, the longer the marriage period was, and the bigger the differential in income, among other factors you have to look at, and there are many, the more likely it is there will be alimony, and how long the term will be. And after all that, you get all those things resolved, you sign a settlement agreement, you'll get divorced if you've established grounds. You can't get a divorce decree, even if you've established grounds, until those things that matter have been resolved. And sometimes, as a result, you'll wind up going to court at the end of all the stuff, because there's not an agreement, and you say, Judge, we can't agree, decide. And there's a person I know as a judge once said, very effectively, when a client, not mine, complained in court, Judge, I'm quoting you now, that decision was not very fair. I say that a great deal because I hear it so often and people think it. The judge said from the bench, you don't seem to understand something. I'm a judge. It's my job to decide things. If you didn't want me to do that, why did you bring me this case? And if people think of that, they'll understand what the business here, what we're talking about today, is really all about. When it really matters, the choice is simple.